Okay, gentlemen, I want to jump right into it. We're covering the Supreme Court on this podcast, and yesterday the court heard oral argument in 303 Creative v. Elenis. This is kind of a piggyback case on the Masterpiece Cake Shop case that the court, at least many allege, punted on the last time they addressed the issue. That was in 2018. The facts of this case are similar. We have Lori Smith, who owns a graphic design firm in Colorado and offers custom wedding websites for customers. But because she opposes same-sex marriage for religious reasons, she does not want to create custom websites for same-sex weddings, which violates a Colorado public accommodation law that prohibits businesses from discriminating against gay people or announcing their intention to do so. So the case is up at the Supreme Court, and the issue is whether applying a public accommodation law to compel an artist or speaker to speak or stay silent violates the free speech clause of the First Amendment. David, you said you read the transcript from the oral argument yesterday. What'd you think?
Well, I thought both lawyers had a tough time. It was, as typical of Supreme Court arguments, it was a vigorous line of questioning. Kristen Wagoner argued the case for
Lori Smith,
the petitioner. Yeah, she faced some very vigorous questioning, particularly from Justice Sonia Sotomayor, essentially about, well, if she doesn't want to design a website for persons in a same-sex marriage, what about persons in an interracial marriage? Justice Jackson and Justice Kagan were also quite vigorous in their questioning. And I think part of what the court has to do from looking at the briefing is the court going to view this truly as the compulsion of speech? Is this another in a long line of compelled speech cases? Is it similar to forcing the Maynards to display live free or die on their license plate? Is it similar to the Hurley case where the gay and lesbian group sought inclusion in a private parade, or is it purely commercial conduct? And so you have the United States government and others arguing that this case really involves commercial conduct more so than speech. And so one reason why I think you're entirely accurate, that this case will, I think, force the court to address some of the underlying speech issues that they did punt on in Masterpiece Cake Shop. Does this involve speech, or is it conduct? Is it really the regulation of commercial conduct, or is it pure speech compulsion? And the speech conduct dichotomy is one that permeates a lot of First Amendment law. When the court addressed Virginia v. Black, the burning of a cross, right? What did Justice Thomas write in his dissent? He said the act of burning a cross was conduct, not speech. So that sort of speech versus conduct dichotomy is something that'll be very interesting to see how the court treats that.
Yeah, but they weren't selling crosses, right, Ronnie? I mean,
yeah, well, it's interesting to me that you mention the dissent in the cross-burning case, right? It was Justice Thomas's dissent in the cross-burning case where he said, no, that's just conduct. Yeah, that's the dissent. And this is something that's frustrated me a bit about the discourse on Masterpiece Cakes and on this case as well. The parties below really didn't dispute whether Smith's preparation and creation of bespoke websites for weddings was speech. I don't think there's any question about that. And frankly, I found that a little bit frustrating in Masterpiece Cakes as well. There was a lot of debate leading up to the argument, and even at the argument in that case, are cakes, speech, or are they not speech? Anyone who has a mixed interest in baking shows and legal doctrine should check out the cake maker's amicus brief in that case, because it's one of the most beautiful briefs you'll ever see with all of the illustrations in it. But what was interesting in that case is there was a finding at the Colorado Commission that the cake was expressive. And I know that you get de novo review in First Amendment cases, you get an independent review of the record. But at the end of the day, there was a finding. Nobody bothered to say, hey, I'm looking at this case in a de novo way. I'm looking at taking an independent review of the record, and here's why I think the cake isn't expressive. Nobody did that. They just simply continued to debate the point. And I found that a little bit frustrating because I think that was one of the reasons, and this is just my speculation, of course, that the court punted on the speech issue because it was kind of a difficult speech issue if you don't accept the finding in the record. Here, in this case, the question of whether this is commercial conduct or whether this is compelled speech, I think that's a question. I don't think there's any underlying question, though, of whether Smith is engaged in speech when she creates these bespoke websites.